Thank you, Kasia. I appreciate it. Welcome to everyone who's online. The first thing that I just wanted to check was there in the document review exercise, we sent round a new set of documents yesterday because there was a mistake on one of the documents. So if you still have the old version at the top of the second page, where it says the recording requested by Charles C. Wright, it should say Charles C. Smith. And that way, everything I say about those documents will make sense. Anyway, welcome to this case analysis and document review training. My name is Stephanie Carroll. I am the directing attorney of the Consumer Rights and Economic Justice team here at Public Counsel in Los Angeles. I actually started at Public Counsel as a volunteer attorney about 16 years ago, and then clawed my way up through the ranks. And I've been the directing attorney for about 4 years now. And this training really came out of my experience in trying to train up newer attorneys at the start of their career over the last few years to make sure that everyone kind of understood what it is we're doing with case analysis, why we're doing it, and how to start off with document review. I think things that can seem really quite daunting when you're first doing them. One of the things that I want to say at the top is that case analysis and document review is something that you perfect over time. Nobody is great at it at the start. And so I understand that most of my audience today are going to be newer attorneys who may be new to this kind of work in legal aid. You might be analysing a case that comes in as a direct service intake. Maybe you're assessing a case for representation or for pro bono placement. And that's the context in which I'm doing this training, expecting that that is what you will be analysing your cases for. But one kind of fundamental point to note at the beginning is just that case analysis is not something that you do just once. It's a process that you go through at many different stages in a case. And so whenever there is a new piece of evidence, it will cause you to kind of reassess and maybe change tack. And so always to remember that it's not a one and done kind of a deal. Okay, so let's dive into who is the client and what is the case. So real kind of fundamental areas. And the first thing is who is the client? Now, I have done thousands of direct services cases at this point. And there are many, many times when you will be approached as though the person talking to you is the client, but actually they're not the client. Maybe they are the neighbor of the client, or the daughter of the client, or the parent of the client, or the social worker of the client. And sometimes that can be very clear from the beginning, and sometimes it can take a while for that to become clear. So it's really important to try and identify who are you talking to, and is that the person you actually should be talking to? Because in general, we are trying to represent the folks who are the real parties in interest in a case. And sometimes that can be difficult to figure out. I'm thinking of, for example, in a foreclosure case, you might get somebody coming to you saying that they're being foreclosed upon. But actually, when you look at the loan documents, you realize the person you're speaking to isn't the name on the loan documents, and that the person whose name's on the loan documents could be a relative or could be a friend who was helping out these people. And so in that situation, you need to sit down with your supervisor and figure out, okay, who are we going to represent? Can we represent both people? But it's really important to have clarity about who your client is. The next big question is what do they want? And I encourage you very much to listen to your clients and to try and get down to the goals of your client at an early stage. And the reason I say that is because what they want might not be something that is possible. For example, if you have a client who says, I want to sue the city for $3 million, and you say to them, well, I hear that, but how about if the city were to offer you some kind of compensation for the wrong that you think that they have done you, would that be something you might be interested? And they say, no, I only want to sue them for $3 million. You know then that that is not going to be a client that you're going to be able to satisfy. And so it's really important to get to the bottom of what it is the clients want. And then as an adjunct to that is, what do they actually need? Because sometimes it isn't clear what the client needs to them, and it's very clear to you. And sometimes you need to thoughtfully kind of re-educate the client about the things that they might need to prioritize. So again, as an example, in a foreclosure case, and I've had many of these cases where someone's come to me to talk about a wrongful foreclosure, but then they say that they say that they are in the foreclosure process, but when we dig a little deeper, we see that actually they're being evicted by whoever the entity is who currently owns that home. So the priority for that person is to figure out the eviction defense, which is the eviction, for those of you who don't know, is a very summary process. It's a very quick process. So it's important to jump on that aspect of the case first. Not to say that there wouldn't necessarily be a wrongful foreclosure case there, but you need to make sure that we figure out what it is the client needs and what they need most. And then another, I think, just general question that we always ask ourselves, especially in legal services, is this a case within your expertise or your firm's practice area? So, for example, in the team that I am the director of, we have a set list of things that we do and things that we do not do. And if something doesn't fall in one of those lists, then we are going to be referring out to someone else. And one of the things I really want to point out to you here is our professional responsibilities of competence. Rule 1.1 is competence. And what that means is that you have to have the learning and skill to be able to do that case. Or if you don't have it, you have a plan to get that learning and to get that skill or associate with another attorney who has that skill. Generally speaking, for most of you, you will be working in departments where you have a kind of a set type of cases that you will or will not work on, or you will or will not be allowed to work on. And so you might not have to dig into this, but I would say always be very, very careful about stepping outside of your practice area, because it can lead to some real problems. Okay, I'm going to try and monitor the chat as we do this. Just bear with me. Okay. Okay, so the next question is this a client or an adverse party for you or for your organization? And there are a number of different things that I think go into this analysis. Firstly is timing. And again, this goes to competence, right? You can only provide competent representation if you have the time and the resources to dedicate to that case. So if you already have an incredibly busy caseload, you are going to be thinking very seriously about taking on a case that walks through the door that has a trial next week. So that is always, I think, a key thing is, does the timing work for you? Is the capacity to take on this matter? And then we move on to client management concerns. And these can be myriad. For example, is the client sufficiently organized? Are they sufficiently invested in their case? Are they responsive to you? Are they easy to manage? And I think sometimes that's important and sometimes it's not important. But I think, or rather, it's always important, but sometimes you'll still want to represent that person, even if they're difficult to manage. But you want to make that decision. what about the folks who are around them? I certainly have had cases where the client themselves was quite easy to deal with, but there are other people, a spouse or a child or a parent in the periphery who constantly want to be involved and insert themselves into the case. And that can be a decision that you're making on your own behalf or on your team's behalf. But it's also a really important thing to think about if you're going to place a case with pro bono counsel, because we want to do the right thing by our clients and find them the best representation. But we also want pro bonos who are going to want to come back and do pro bono work for us again. And so there is always a balance there. And at the very least, if you're thinking of placing cases down the line, you want to be able to alert the pro bono if there are particular issues with the client that they should be happy and comfortable with before they take on representation. Other things that may be important when thinking about the individual client is, are they themselves sympathetic? And again, sometimes that matters and sometimes it really doesn't matter. It depends on the case that you're dealing with. But I know that I certainly have had cases which were not great cases, but the client was incredibly sympathetic. And sometimes you can get traction based around the difficult circumstances of your client. So it's always a good thing to be assessing and throwing into the mix. Is your client someone you can get hold of? That is often very, very critical. And what does your client think about participating in litigation? Are they going to be able to cope with a deposition or cope with being put on the stand in a trial, should it come to that? Are they a good historian? Do they have a good memory about what happened? Or do they have a good reason why they don't have a good memory? And that comes to the other issue, which relates back to who is your client, is your client competent? Is your client competent enough to instruct you? So often with elder clients, and not just with elder clients, but I think it appears more frequently in the elder populations that we serve, is they need a little bit of extra help. And sometimes they need to have someone who's a power of attorney. In some cases, they need to have somebody who is their conservator in order for you to really be able to represent them properly. And so all of those considerations need to come into the mix. And then as legal services providers, we always have income guidelines, income restrictions, geographical restrictions. They might be linked to particular grants. I know that, I have certain grants where I can serve people in lots of different counties. I have certain grants where I can only serve somebody in a particular county. I have a grant that will allow us to go over IELTA guidelines, but others that won't. So you're always managing those grant and kind of legal services eligibility issues in addition to things related to their clients themselves or related to the timing of the matter. And then we look at, is this an adverse party for you? Now, obviously there are, potential conflicts, and those always have to be considered, and we all need robust conflicts management systems to capture that. But beyond just a simple conflicts management check, we need to do some due diligence and do some investigation. Do we know who the adverse party is? Firstly, sometimes we don't even know that. But if we don't know that, is it possible that we can find them? If we do find them, are they a viable defendant? If you want to get money out of somebody who has disappeared to another country, for example, it might be incredibly difficult to get redress even if you win the case. And that is really important because our resources are extremely limited in legal services. And so we need to try and help as many people as we can, but we also want to really help them. Getting somebody a default judgment that doesn't actually result in any redress, in my view, is not something that I'm going to have my team spend years working on. So all of those things are important. And then just circling back to conflicts a little bit, you have like actual conflicts and you have potential conflicts with individual adverse parties and indeed with clients. But I think for a lot of us in legal services, we're also looking at whether there are any positional conflicts. And by that, I mean, are you going to have to argue something to win this case that you would be arguing against in another case? And this comes up a lot when we're trying to get pro bono representation. In my unit, we're dealing with consumer rights. And so some of the things we deal with are things like predatory lending. It's very difficult for me to place cases against financial institutions because even though the pro bono may not have a conflict with that particular institution, it would force them into a position where they're making arguments that they would normally be on the other side of for their clients. So that is also a really important thing to think about in terms of this adverse party. Okay, so let's talk about getting into the facts with a client. And I think, the key thing is, does the client story or the potential client story, does it make sense? Does it hang together? Can you explain it to your supervisor? Could you explain it to a jury? Because if you can't understand it and if you can't explain it, then there will be a reason for that. And that is the kind of reason that makes you think maybe this isn't the case for us because we can't really get to the bottom of exactly who did what, when, and why there is an issue here. One of the key things to do with every client is to build a chronology about their case. And this is something I would do from intake. And it can be difficult to pin people down often on dates and on when things happened and in the sequence in which they happened. But do your best with each client. If dates are really important, and sometimes they are if you think you're nearing a statute of limitations issue, you are going to want to really press that client to try and figure out when something happened. And you can use all sorts of techniques to do that. So you can help in sequencing by saying, okay, did this event happen before or after this other event that you've told me about? Or if it's about pinpointing a particular time, like a signing of a contract or something, can you remember what was going on in your life at the time? Oh, yes, it was my husband's birthday. Wonderful. Now you've got a marker. Now, obviously, that's an easy example. It's not always that easy, but scratching the surface to try and get down to create a kind of chronology that makes sense is, I think, a really important thing to do. And then can we verify the client's story with reference to witness or written evidence? And that is, I think, really important. We need to kind of triangulate. Something that I will be saying again later is what we do with our clients is we trust, but we verify. So we don't question what they're telling us if they're talking, and often, they are the experts in their own lives. So they generally know a lot more about what's gone on than we ever will. But we always have to verify what they're telling us with whatever available other sources there might be. And often that's through collecting documents from the client to kind of back up what they're saying. But there are lots of other places that you can look. There are court records. There are databases like Lexis or Property Shark for people who have access to things like that. There's lots of things in the public domain often. There may be news articles about the adverse party that talks about some pattern or practice that this client's talking about. There could be a consent decree out there. So a consent decree, for anyone who doesn't know, is basically like a settlement between a governmental or regulating body with, one of its licensees. And it says that, wrongdoing has been found, or that no wrongdoing is being admitted to, but that the company is going to do X, Y, and Z going forward. And so you want to be looking for those or other similar cases. Another great thing that folks should all know about, I'm sure most of you do, is something called the Wayback Machine. If folks are talking to you about websites and representations that they saw online that you can no longer find, there is something called the Wayback Machine that will pull archived web pages so that you can see what folks may have been talking about. And then figuring out what are the gaps and knowing where to go to fill them. And I encourage all of you, when you are presenting a case, to your supervisor. Maybe you've written an intake memo about what's happened, but be proactive in pointing out where are the gaps? What are the things that we don't know, and what are the things that you think we're going to need to find out to be able to make a decision about whether we're going to help in this case or not? All right, and then getting into the law. So we need to know what causes of action are implicated. And for anyone who is not already familiar with CACI, C-A-C-I, jury instructions, I suggest you go ahead and dive into jury instructions, because they are a great definitive guide of all the elements for each of the causes of action that you will find certainly in California courts, civil courts. And it will spell out, the different elements and what the law is underpinning those. So where to find the law that underpins those different elements. And you need to know that, because you need to know what are you going to have to prove in this particular case. So if you take a fraud case, for example, there are certain things that you need to know about a fraud cause of action. And one of them is that you have to have detailed fact pleading if you are pleading fraud. That means you have to cover the where, when, what, how, who, all of those questions in detail in your pleading, or else your pleading is really going to be subject to attack. So that's very important. And that also helps guide you talking to your client, because if your client cannot tell you a very detailed story, that is going to call into question, either their memory or really what happened. And it often leads you to investigate areas further and figure out that actually maybe things didn't happen in quite the way the client thought. And that can be very important. So what research do you need to do? And again, when you're talking to your supervisors, I would go to them with a research plan. Like, oh, well, I'm thinking of looking at this, not just going and saying, oh, I don't know what to do. So always have some kind of a plan, some kind of a structure that you think you're going to follow. And then you can be corrected and people can say, no, don't bother looking there. You really want to go and look over in this place. That's where you might find something more useful. What are the statutes of limitations that apply? This is absolutely critical. And I think it's something that when you get caught up in a client's story, you can forget all too easily. Somebody may have an incredibly compelling case, but if they are outside of the statute of limitations, that case is not going to get very far. Now, again, as I alluded to before, sometimes you have such a sympathetic client that you might be able to get some help for them, even if the statute of limitations has passed. Because when we are advocating for our clients, and this may depend on which organization you work for, but at public counsel, where we're allowed to engage with the media, for example, sometimes there is a strategy for advocating for that client that isn't in the courts or strictly legal, that can also be out in the public domain. And so you need to kind of think about that. But for most cases, most of the time, if your statute of limitation has gone, then that is not going to be a case you're going to want to take on. Looking into what are the remedies available, and do those remedies match up what the client might want? That is something that you need to be thinking about. And one of the things I think we have to be mindful of, and I think in legal services often our clients are okay and they don't get taxed on some of the awards that they get in terms of attorney's fees. But if they get damages, they may get some tax on those things. So we need to think about those things, like, is this going to be helpful to the client in the long run? What's it going to do to the client's situation if they win? Is there going to be anything harmful, anything that might stop them getting benefits that they need? So you always have to be thinking ahead to the different scenarios and how they might play out for your particular client. Okay, so that's the kind of basic rundown of case analysis. But as I said at the beginning, it's a constant thing. So every new piece of evidence you get, can change that case analysis and can change your tack or can change whether you are actually going to take the case on or not. So let's have a look now and start getting into document review. And there's a nice picture here of a huge pile of papers. I'm sure many of you will have, or if you haven't already, you will in the future see piles of paper much bigger than that, or electronic piles of paper much bigger than that. And so the question is, where do you start and what are the important documents? So what documents are important really, really depends on your case. And there will be certain documents that are always critical in a certain type of case that are entirely irrelevant for something else. But from the intake, you need to be identifying any document that you think is going to support or evidence what that client is claiming. So if they talk about there being a contract, or if they talk about they saw an advert for something, or if they talk about like anything that would have been written down that led them to believe whatever it was, you want to see that document. You want to see that contract. You want to see that property deed, whatever it is. You want to actually look at it. And that goes right to the heart of kind of cases. If clients said they've filed a case, you want to see that. Whatever you do, you don't just take someone's word for it. You want to see everything that's backing up their claims and what they say happened in their particular story. And then you also want anything that evidence what the other side is or might be claiming. And so, you know, I think it's really important when you're talking with clients and establishing a kind of position of trust with them early on, that you make it clear that they have to be absolutely open and honest with you. And that if there is anything that might support the other side or might harm their case, it is so much better for them to let you know about it. If they understand that, sometimes they won't understand that something could harm their case, but to the extent that they might understand, it's really important to get from them, not just everything that supports their position, but everything that could be used against it, because that's how you can build a strategy. If you know what's going to be thrown at you, you've got a much better chance of figuring out a way to get around those things than if they come out of the blue in a deposition, say, later on. And anything that might be relevant to a defense. So, you know, if you're in a debt collection case and somebody said, well, my identity was stolen, you know, you're going to want to ask them, okay, did you do anything when you knew that? Did you file a police report? Did you file an identity theft affidavit? Because did you make a complaint to the credit bureaus? Because those things are really important to back up that as a defense in that situation. And then I think you want to be thinking about like what categories of information are important. You know, what will be relevant for any case? And again, I'd say, you know, anything that backs things up, anything that is contract, if it's a contract case, a property deed, if it's a property case, it will kind of depend on the case. But anything that is the core documentation or evidence in relation to that case. And then if it's a specific type of case, you might be looking for something very specific, or you might need to see something very specific to help you figure out if this is the case that you want to look at. And that is something that you'll discuss with your supervisor. If it's a particular type of case, you know, generally they will spell out, all right, this is what you're going to be looking for in this pile of documents. This is what we need to see first and foremost. And then I am a big spreadsheet queen. If there's anybody who does not know how to use Excel spreadsheets, learn it, use it. It is so much better. Don't use Word tables and documents. Please use spreadsheets. And I know that in big firms, they have, you know, lots of great AI capabilities and lots of great document management systems that we often don't have. But I would say a few things about that. I think as you're learning to do document analysis, it's really, really important for you to be kind of building those systems so you understand what's important and how those systems can work. And I think I would challenge any AI to be able to sensibly read any of the documents that you've been given in the exercise here, because they are, I would say quite typical of the kind of things that you can expect to see a lot of the time. Poorly photocopied, can't really tell what's going on in a lot of them. And I think that it's difficult to see any system that could just take that and extract from it the things that you might want to know about the documents. So build a spreadsheet and you build it as you go. And by that I mean is you will start off with a spreadsheet with certain kind of categories, and we'll talk about that in a little while. But you will realize as you're going through them, oh, I've just noticed this seems to happen a lot, and I want to now put in a column in my spreadsheet to highlight every time that happens. And so you will be building as you go, and sometimes you'll be going back to page 1 again and, reviewing documents again to see if that particular thing that you just noticed comes up from the start. But that is, I think, a good way to get to know your documents. So what documents are important? There are some documents that are always important. It's always important to get anything related to filed lawsuits. And, it can be really difficult because sometimes there can be volumes and volumes, but I think you definitely want the operative pleadings, the latest complaint, the latest answer or demurrer or, response. And then if there are any dispositive motions or any motions on calendar, you're going to want to see any briefing related to that. And you're going to want to find out if there's any discovery outstanding, and, what may have been said already, or what may have been asked already. Contracts and agreements are always generally important. And I see there's a question in the chat. Are there any Excel legal templates you can recommend for those of us who are Excel challenged? Not that I can think of, but what I would say is if you can make a table in Word, you can make a table in Excel. And the reason why Excel is so much better is that you can, for example, if you're putting things in a date order, you can go through lots and lots of documents that may have lots of different dates, and then you can press a button and sort everything into the right order. And I think chronologies often are the key to all mysteries, right? Once you actually put everything together and you see how the sequence of events, then that's really, really critical. So I'm sorry, I don't have a great Excel template, but I will show you later a spreadsheet that I very quickly knocked up in relation to this document exercise to give you an idea. Okay, so contracts and agreements, very important. Any correspondence that has happened, any mail, email, text messages, direct messages, if people have them, if somebody took a screenshot of a Snapchat, that could be useful. Anything at all that's written and might go to prove something that you need to prove or disprove. Official records, so it might be employment records, real property records, ownership records. If you're doing mal kind of cases, medical records, incredibly important. Those are the things that are going to be central to your case. If there are any recordings or photographs, I will just issue a little warning about recordings. 2 warnings about recordings. If you are going to be recording anybody, they need to know that you are recording them. If you are talking to anybody about the case or consulting with anyone or interviewing a witness and you're recording it, just know that that also could be discovered by the other side and you might not want that. But critically, like often people will come to us and will say, well, I have a recording that they said X, Y, and Z. And I'm like, okay, that's great. Did they know that you were recording them? No, they had no idea. It's like, okay, well, that's a criminal offense in the state of California. So we're not going to be able to use that. So always be careful about recordings. Photographs can be great and very important, particularly if it's straight after something happened. And then are there any notices, any legal notices that have been sent or attached to the door, anything like that? So where do you start, right? You've got a massive pile of documents in front of you. What I would say is, is it possible to put it in any kind of order? So we might, for example, have a debt collection client who has 3 separate cases, and they may come to us with a big bag of their documents. And so can we quickly sort it into the separate matters? You know, we have a matter for Bank of America here, and one for Synchrony Bank here, and one for HSBC over here. So can you sort it by matter? If it's a small enough pile, can you do a quick date sort? Because I think that can really help. Or are there specific categories? You know, do you want to separate out everything that's an email from everything that looks like a contract or a financing agreement? And really, what I would always be mindful of when you're thinking about cases, when you're looking at documents, when you're putting together any kind of analysis, is what would be helpful, what's helpful to you, and what would be helpful to somebody else. You know, what do you think, you know, your supervisor would want to be able to see quickly? Always trying to put yourself in somebody else's position to figure out whether or not what you're asking for kind of makes sense and whether it will be explainable to somebody else. I think the second thing that you want to look at in terms of putting it in a kind of order or where you want to start is, are you looking for something specific? Often for example, there's a whole set of financing cases that we dealt with, and we were always looking for specific types of documents. So one that created a lien on the property was really a really important document. We wanted to get to that because it would tell us all sorts of things that we needed to know about the case. So you want to know, is there something you're looking for specifically? And then, you know, if you can do none of those things, just pick up a piece of paper and start looking at it and trying to figure out what it is. And I think that you will often come across things, and if you have never done anything to do with property, you'll have come across them in the document exercise here, where you look at things and go, I have no idea what this thing is. So what I'm going to ask you to do is just to try and figure it out, okay? And again, use a spreadsheet. So what are useful general categories? And these will help you in figuring out what a document is. I would say date and possibly time are always really important bits of information in any case. If you're looking at any kind of pleading, or if you're looking at any kind of discovery, critical is always the date of service. So, you know, you might get a complaint and it might have 3 different dates on it. It might have the date the complaint was filed, it might have the date that an attorney signed it, and it might have a different date on the proof of service. The proof of service is the date from which all civil procedure guidelines run, and that's the date that's going to be very critical. It's not to say other dates aren't important, but that is for anything that's in a legal case, you're going to want to know that date. The document title, does it have a title? All right, if it doesn't, what do you think it is? What does it purport to be? Does it seem to be some kind of an agreement or some kind of contract? Does it appear to be some letter or some notice? There are lots of things that you can say about documents without understanding what all of them are. So pick out what you can discern and make sure you're clear about, you know, what's clear and what's not clear. Where's the source? Where did you get it? Where did this come from? And again, you know, that goes back to things that I was saying about recordings or whatever. There are certain documents that you may get hold of, or you may not know where they came from. And those are very difficult documents to get into evidence, because you have to be able to say what the document is and say what the source of the document is. So it's really important to know, what documents do you have, and are there documents you can actually use in the case? And then, do we actually have the document? Sometimes we don't have documents. We know they exist. We've read something in one of the documents we do have that alludes to another document that sounds very important, but we don't actually have that document. So have we seen it? If we haven't, can we get hold of it? And again, always trust but verify. I'm reminded of a case recently, well, not that recently, but where it was a property case. And in property cases, if you file a case about the title of a house, you should also file something called a lis pendens in at the county recorder's office. And that basically puts the world on notice that there's a lawsuit about this house. So nobody's really going to get involved with buying or selling it because they're on notice that there's a question over the title. So it's a critically important document. And, you know, I had someone come to me and say, yes, lis pendens was definitely filed and the client said so. And I said, well, have we seen it? And the answer was no. And when we eventually got the document that this client thought was the right thing, it was entirely the wrong thing. And so we had to move very, very quickly to right that situation. So have you seen the document? Trust but verify. And, you know, where has this come from and what do you think it is? So other kind of useful categories are like what type of document is it a letter? Is it a contract? Is it an email? Is it a business card? Is it a text message? What is it? Is it complete? Do we know that we have, you know, we have some pages of a document that say page 3 of a 48-page document, and we have pages 7, 8, 9, 10, 11, but we don't have the others. So do we know if it's complete or not? Is it signed? If so, who signed it and when did they sign it and how was it signed? So, you know, we live in a day of electronic signatures, which, you know, sometimes make things a lot easier, but also can make things quite tricky, improving things for our clients. But, you know, have you looked at the DocuSign audit trail? Can you figure out when it was signed, like what IP address it went to? Is this document a duplicate? And are you sure it's a duplicate? I have had many cases where there are lots of documents that appear to be the same, but there are small changes that indicate that at some point somebody was given a document slightly different to the one that they thought they were signing. And those can be very kind of critical to point out those differences. And then another general comment section that you'll see on almost all of my spreadsheets is the comment section. Like, what is it I'm saying about this document? Why do I think I need to write a comment about this document? And it might be you just writing a comment that says, this is clearly only half a page of some bigger document. Or you might want to point out that, you know, the signature on this document looks very different to the signature on this document. But you're going to want to try and get as much information as you can and point out as many key points about that document as you think are needed. And then kind of getting into some specifics. So, you know, who's the document to? Who's it from? Is it somebody who's transferring something to somebody else? You know, so who are the parties? If you're dealing with mortgage cases, you know, who's the mortgagee, who's the lender, who's the borrower, who's the mortgagor? Those things can be very important. Document numbers can be very important. Does it have a bait stamp? So anything that's come from the other side in a case or anything you've produced in a case should have its own unique identifier, which is the bait stamp number. And that might be, you know, useful for you to know. What I often think of when I look at that pile of documents that's in the picture, I often imagine my opposing counsel getting the pile of documents and then throwing it up into the air before they collect it at random and pass it over to me. And sometimes you can see that by the way the bait stamps numbers aren't sequential. But in any event, it's often not very helpful, and you're often trying to pass together documents and pieces of documents, or like a whole document from various different pieces throughout the production. Are there any key mentions? Are there key players named? Are there key organizations named? Are there certain items or issues that are raised? Just bear with me a moment. So, for example, if you're looking through, you know, the notes of a financial company that talk about the phone calls that people have, you know, are we in these different times the customer called and complained? Like, you might want to highlight all the times that they called to complain about something. Is it a hot document? And that just means, is this one of those key documents that will really help crack open this case or really help go to prove a particular element of this cause of action? And, you know, those are always the documents, the interesting documents that you're looking for. But what does it go to prove? Always, you might see some really interesting documents, but then you have to sit back and go, wow, that was really interesting. And it mentioned some really interesting people that I've heard about, but does it actually tell us anything at all about this case that's going to be useful? And then just know that the devil is in the detail, often with documents. I once worked on a medical malpractice case where somebody was in hospital and lots of medications have been administered. And every time a medication was administered in the records, there was a whole host of tiny text about that medication, it seemed, or contraindication related to the medication. And when we looked through it, and several of us had looked through these documents, many times, but right in the bottom of one of these dense bits of very tiny text, I found a reference to why that particular medication had been administered. And I remember being in the deposition for the doctor and raising this, and my opposing counsel's face drained, which told me that they hadn't seen it either, because it was just in this big block of text that everyone thought, oh, I've seen that before, it's just going to be the same. So always get into that detail and, try and find out exactly what's going on. All right, so I just want to move on to the records analysis. We've got about just over 10 minutes. And you should have had an email and some pages of documents. And so the questions, and I'm going to want people to raise their hands and then we can take you off mute, is, what are we trying to understand? So that's the first question. What are we trying to understand about this case? Come on, don't be shy. Let's have a hand up. There are no wrong answers here. See, this is the only problem doing a webinar, is that you can't pick on people. You're all probably heaving a sigh of relief. I mean, I think the key thing we're trying to find here, yes, thank you, Elaine in the chat. Yeah, who owns this property? That's absolutely critical. And does our potential client, Charles, own this property? So is he on title? Does he have any rights? I mean, these are the things that we want to try and find out. And I'm going to carry on with the questions, but I am going to share a different screen, if I may, because I'm going to share, hang on a sec. Okay. Kasia, I don't know because I can't see what other people are seeing, but can other people see that spreadsheet?
Yes. Yeah.
Okay, great. So this was a spreadsheet that I knocked together very, very quickly to try and figure out what was going on in this case. And I think one of the, so I think hopefully you can see what I'm saying, which is I started with the date that was on the document and then the date that it was recorded and the time. I don't think times made any difference in this case, but I wasn't sure at the beginning what the document seemed to be, who it was from, who it was to. And from this, one of the things I think we can see quite clearly is that from 1986 onwards, Charles Smith does not appear in title. Now, that doesn't mean he doesn't have any rights, but it means that that's what the chain of title is telling us at the moment. And that's going to be potentially an important thing. And what I tried to do here when I was looking at these documents was to put in the documents, but also to put in things from the email. So we have things, we know there was a lawsuit and we know that he paid off the mortgage, or this is at least what has been told to us. So I tried to put those into the chronology. And so I guess I'm going to stop sharing that now and go back to the presentation. Are you seeing the presentation or not?
No.
Okay, Bear with me. Okay. Are you seeing the presentation now?
Yes, thank you.
Excellent. Thank you very much. And so, these documents show us, I think, lots of things. I think one of the things that they show us is we don't have the full story in this set of documents. There seem to be all sorts of things that have happened that don't follow one another. Like the chain doesn't go directly from one person to the next person. And so one of the things that we might have to do is go to the recorder's office and actually pull all the documents or get a much more complete title report to see what's happening. So one of the things, like, what are the things that occur to you as you look through the documents? So just please put in the chat or raise your hand. Is there anything about any of these documents that you think looks a bit strange or that you think might want to be looked into more? And one of the things that I spotted, signatures. Thank you, Fernando. Fernando, can you come off mute? Can Fernando be taken off mute so Fernando can tell me about signatures?
Yes, can you hear me all?
I can hear you.
Yes. So it looks like the signatures there, it looks like they put a little post-it note on top of the original signature, and they put a new signature on it, and the signature does it. The color of the paper, one part is white and the other one is like a little like yellow type of color.
So that's good. That was me changing those signatures so I could change the documents. But there's something like, let's assume that those signatures are okay, the ones that have the yellow ones. Assume that they have. And let's all of us look at the signature for Diane Smith on page 2 of 17 and then compare it with the signature of Diane on page 13 of 17. Does anybody put your hand up if you notice a difference? I can't see if there are hands up, but I'm hoping there's a lot of hands up. So when I look at this, what that immediately said to me is, what's happened to Diana Smith? Let's ask our potential client, Charles, and let's see if he knows whether his sister has maybe had some health event that means that her signature is so radically different than it was before. Or are we perhaps dealing with an additional party in this property dispute, maybe somebody who's forging a signature? We don't know that, but these are certainly questions that I would be asking and raising and trying to get to the bottom of. And then, is there anything about the entirety of these documents that you might want to know more about? Again, hands up, anyone who thinks there's something about looking at these documents as a whole that they would want to ask some questions about. Okay. I see we have no takers. So I'll tell you what I thought was interesting. We have 16 pages here out of 17 pages. So my first question is always, what's on page 17? Is it something that, we might not want to see? Is it something that might be problematic? We don't know, but we need to know where that page is or if there was something interesting on it. And at the bottom, it says on each page, requested by May West. And I'd want to know, who's that? who's that person? It's not somebody who works with us, so I don't know who that person is. So where did these documents come from? Joshua says in the chat, there are some annotations on page 2. This is a gift and this is a conveyance to secure a debt. I'm also curious what the debt is. Absolutely. What do these things mean? And can our client shed any lights on those kind of things? So, you know, I think the question about what these documents tell us is, well, they tell us some things and they don't tell us a lot of things. But your job when you're talking to your supervisor, you're presenting the case, is to kind of point those things out. So when I responded, or if I were responding to this email, I would have said things like, these documents are absolutely incomplete and we can't just make a decision based on these documents. That there appears to have been transfers from Diane and the mother, from Diane and Charles, and that go backwards and forwards. I'm presuming the mother is Janet, also known as Jeanette, in these documents. The foreclosure sale that happened probably relates to the lawsuit alluded to in the email, or it may well do, and we need to figure that out and see if we can get hold of that lawsuit and figure out what happened there. And then you have transfers from Diane to herself, one of which is correcting her name. And then you have these deeds to Home Alliance. And so from what I could see, he doesn't seem to have been on title since 1986, which doesn't make any sense if he was paying a mortgage till 2005. And what do I want to see there? I want to see the mortgage statements. I want to see evidence of payments he made. I want to see if there is a lien release related to that mortgage that he was paying off. And, you know, if he really was on title and his sister signed something false and the current owner, Home Alliance, they might not be what we call in the property world a bona fide purchaser, because one of the things that a purchaser needs to do is inspect the property. And if there's someone living there who isn't the person who's on title, then you're supposed to do some investigation. So that was all I could really say from what we got, but I could point us in at least in the right direction. And one of the things that was clear is that this person was being evicted and somebody needed to represent in the eviction, but also to get to the bottom of some of this and potentially go in and file a temporary restraining order to prevent the property being sold on further from this Home Alliance whilst we got to the bottom of things. So that's it from me. I don't know if we have time for any questions or if folks have any questions. And if not, I'm going to try and move the presentation on. My name's Stephanie Carroll. That's my email address if anyone has any questions for me. Yes, absolutely. The slides for the presentation should be available. I sent them to LAAC, so they should all be available. Anyone has any questions, please let me know. And otherwise, I'm going to pass it over to you, Kasia.
Thank you. Yes, the